In July 2009, Governor O'Malley put together a joint task force, and they continue to look at these issues. Their audits suggest that as many as 20% of all employers misclassify employees. And what we're really talking about, because workplace fraud can mean a lot of things in a lot of different contexts, we're talking about the idea that you have misclassified someone. Someone is an employee, but you have classified them as an independent contractor, or otherwise failed to classify them as an employee. This has an effect. It has an effect in terms of whether or not payroll taxes are withheld, whether or not there's unemployment that can be pursued, workers' compensation, sometimes prevailing wage rate, living wage rate issues. There are a number of reasons why that classification or failure to classify as an employee is a significant issue. It isn't a new issue, though. If you go into the case law, federal and state, you'll find many agencies have been struggling with what's an employee, what's an independent contractor for many years. Maryland's unemployment has had a standard in place for many years, and that standard has now been folded into this new Workplace Fraud Act. When this was first proposed, the Chamber looked at it and recognized, again, there are legitimate issues here. There are members of the Chamber who are, to use the phrase that everyone uses, working hard, playing by the rules, classifying people as employees because they are, and they are being put at a disadvantage when someone that they compete with doesn't take the same approach. Having said that, there were a number of concerns with the legislation. When we first started to see it a few years ago, it had a lot of bells and whistles that were really shocking, like criminal implications. Many of those issues ultimately got sort of pulled out. Nevertheless, there was still concern about a number of things, and there was communication. President Snyder sent a letter to Secretary of State McDonough and to Secretary of Labor then Perez, specifically saying, you know, we strongly oppose intentional misclassification. We're nevertheless concerned with this law. We're concerned with some of the mechanisms. There's no safe harbor. There's a private right of action, and I'll come back to that in a minute. There's no small business exemption. There's no prior notice before a government regulator comes on site. There are substantial requirements with respect to maintaining records. The fines are too high, and there's no substantial compliance standard. And in addition to that, there are some vague standards, or then were, with respect to debarment.